is twofold. The first is that we mentioned it, but did not sufficiently deal with it in the papers. That's the first criticism. And the second criticism is that the Judge Akuo also did not deal with it. And the underlying legal premise is that it is a requirement. Mr. Mpofu calls it a fourth requirement. So let me first deal with the evidence, what transpired. The prospects of success are dealt with in the founding affidavit of Ms. Mon at page 341. So if you go to page 341 at paragraph 11, she states there, despite the lack of prospects of success on appeal, says lack of any prospects of success on appeal. Shortly after the judgment was handed down, the J.G. Zuma Foundation issued a public statement indicating that Mr. Zuma intends to appeal it. The statement issued on Twitter at 11:25 on 7 June 2023 is attached. It was issued within 3 hours of the judgment being made available. Then it is also mentioned, so it's clear there, the assertion is made that there are no prospects. In fact, it says lack of any prospects of success. And at that point, we don't yet have the application for leave to appeal. Then it is also dealt with at page 346 at paragraph 24.5. And you will see there, it states the prospects of success on appeal by Mr. Zuma are so poor that his application and likely series of applications for leave to appeal can serve only as a dilatory tactic in his own criminal trial and to negate the protection that I'm afforded by this court's order against further unlawful harassment and intimidation. So in two parts, it is positively asserted that there are no prospects of success, and then in the second part, they are so poor that any pursuit of that leave to appeal would be dilatory. Then the leave to appeal is brought, and this is then dealt with in the reply. So you will see at page 493, which is the first time it is dealt with in the reply. At 493, at paragraph 11, and it's a full exposition there of the arguments to be advanced. And it states here at paragraph 11, at page 493, fourth, Mr. Zuma contends that his application for leave to appeal has good prospects of success. It appears that Mr. Zuma places primary reliance on the argument that the full court's order violated the principle of subsidiarity because it granted an order that he contends is not permitted by Section 14.2 of the Superior Courts Act, and hence that a constitutional challenge to Section 14.2 was required. This argument has no merit whatsoever. It is, with respect, patently bad. Without purporting to be exhaustive, the principle of subsidiarity finds no application in these circumstances. Mr. Zuma ignores all the precedents dealing with the court's duty to prevent an abuse of its process. Mr. Zuma proceeds from the erroneous premise that an unlawful and valid criminal prosecution was instituted against Ms. Mon, and Mr. Zuma has misconstrued the authorities on which he relies. The issue will be addressed in argument to the extent necessary. And then it goes further at page 494 at paragraph 13. And there, the attorney on behalf of Ms. Mon addresses the issue of the honors squarely. And then he says, Mr. Zuma claims that Ms. Mon has failed to discharge the honors on the applicant to establish reasonable prospects of success on appeal. I deny that there is any such formal honors. However, even if there is, the prospects of success are readily apparent from the reasoning of the judgment and the grounds on which the full court found Mr. Zuma's institution of a private prosecution against me to be unlawful. The prospects of success are, in any event, a matter for legal argument. So again, it is in paragraph 11, there is a full argument. In paragraph 13, it is stated that the prospects of success are apparent from the reasoning in the judgment itself. So they are so poor that you simply have to put the judgment on one side and put the leave to appeal on one side to realize that they ought to be dismissed without more. But they go further. The discussions about this issue goes further. You will see at page 496, paragraph 18, where the legal argument continues to justify why the judgment was correct. It says, eighth, Mr. Zuma repeatedly attempts to present his private prosecution of Ms. Mon as akin to any public prosecution. It is manifestly not so. The Constitution confers the power on the NPA to institute criminal prosecutions and requires that this be done without fear, favor, or prejudice. Mr. Zuma fails to recognize that his prosecution of Ms. Mon is an unlawful prosecution pursued in a private capacity for an improper and ulterior purpose, and which constitutes an abuse of the court process. Then so that would be at paragraph 18, and then the last is at page 499 at paragraph 26. It's a long paragraph. In fact, it's both paragraph 26 and 27, which goes to the issue of how this private prosecution violates Section 16 of the Constitution. And in any event, it's unlawful because there was not a prosecution that was applicable to Ms. Mon. So, contrary to the assertions made that prospects of success are not dealt with, they are in fact comprehensively dealt with in at least 1, 2, 3, 4, 5, 6, 7 paragraphs. They are also dealt with in the judgment at page 593, which is the last volume, I think it's volume 4. At page 593, at between paragraph 583, between paragraph 33 and 37. And in paragraph 36, which is at 584, what is stated there is not that the court will not address prospects of success. It simply says, look, we will in due course deal with the prospects of success when we receive the application for leave to appeal and address it. And then they say, but insofar as the leave to appeal is based on the issue of subsidiarity, a mere perusal of the judgment will show that it was dealt with in some detail. If indeed the main thrust of the first respondent's application for leave to appeal is the failure of the court to deal with the subsidiarity aspects, then prospects of success are indeed slim. So it's paragraph 36 of the judgment at page 584. So far from eliding prospects of success, they say, look, we are still going to deal with prospects of success fuller, but insofar as they're based on this aspect, we find that they are slim. So it's in the founding affidavit, it's in the replying affidavit, it is in the judgment. But prospects of success in relation to what precisely? Because there are two prospects of success in the issue. One is what Mr. Badlander addressed, which is the prospects of Mr. Zuma successfully prosecuting his intended accused. The other is the prospects of success of Mr. Zuma overturning the findings of the High Court that his decision to privately prosecute Ms. Mon and Mr. Downer was an abuse and should be set aside on that basis. So it's the second category of prospects of success that are relevant, which is he going to succeed or is he likely to succeed on appeal? Mr. Badlander has made the point that the prosecution itself is based on a contrivance. And it's clear that as far as Ms. Mon is concerned, it's actually a contrived prosecution. And we see this just by observing the number of times Ms. Mon has been mentioned even today. She's actually a peripheral player, but she remains an accused person. But we also see that it is the prosecution against her is contrived for another statutory reason. Ms. Mon is not mentioned in the Section 7 nolle prosequi. That was the finding of the High Court. There is no debate that she was mentioned. She's not in the certificate. You have no right to prosecute anyone privately under Section 7 of the Criminal Procedure Act unless they are in the nolle prosequi certificate. She is also not in the number of parties that were alleged to be suspects when the affidavit was submitted in favor of or in motivation of the nolle prosequi certificate. She's not mentioned there either. So she's not mentioned when the process is instigated. She's not mentioned when the certificate is issued. She's not mentioned even in the second certificate at all. So there is no basis at all to prosecute her because there is no viable case in the absence of her name being identified in the nolle prosequi. And we see this as a jurisdictional requirement that is expressly mentioned in Section 7 of the Criminal Procedure Act. That was the finding of the High Court. But in addition to this being a finding of the High Court, the High Court also expressly, comprehensively explains why the prosecution of Ms. Mon is an abuse by Mr. Zuma. And you will see this in the judgment of the High Court. It's in volume, I think the judgment is in volume 2. Yes. And the paragraphs that are relevant, you will see from page 387. That's where the judge pertinently addresses itself to Ms. Mon. So at page 387, the first finding of relevance is at page 388, paragraph 120 and 121. So in 120, the judgment finds, prior to the institution of the private prosecution, she has reported on matters involving the public protector and politically charged matters, which has drawn criticism from the Jacob Zuma Foundation, supporters of the respondent, and members of the respondent's family. As a journalist, she is seen as part of a hostile media with menacing commentary. She is regarded as an implicated party in matters of Downer and co-accused who has provided a statement to the police. And then in paragraph 121, it is evident that the respondent, that is Mr. Zuma, harbors great hostility towards her and is demonstrated in his affidavit by the respondent's associates and supporters. And then they deal with all of the tweets. But if I can take the court to paragraph 125 at page 389, where it is stated that the court says, having regard to the respondent's answering affidavit, his personal animosity towards Mon is exposed. She is alleged to have colluded, conspired, and been in partnership with the state prosecutors perpetuating a false narrative about his conduct towards litigation and the delays in the criminal trial. This is repeated on a number of occasions in the answering affidavit, and his hatred, impatience, and vitriolism towards her is patently obvious. And then paragraph 28 and 29 of Mr. Zuma's answering affidavit are extracted. And paragraph 126 is also relevant. And then paragraph 130, which is at 391, states the following. Mon also indicates in her affidavit that the respondent will stop at nothing to malign her and falsely implicate her. As a further example of this, she alludes to the respondent's reference that she deleted tweets on 9 August 2021 relating to medical information. In support of this allegation, he annexes Annexure JZD7. In support of this, that's a grammatical mistake. However, such annexure does not purport to support this contention, but further evidences an attempt to manufacture evidence against him. Now, this is an extremely serious finding against a purported private prosecutor. A finding that an ordinary prosecutor under the NPA has manufactured evidence would be extremely serious. If that prosecutor had been an advocate, they would have been struck. But this is a private prosecutor who purports to act in the public interest in pursuit of a claim that he says justifies private prosecution. But it is found by the judges that in the course of doing so, he has manufactured evidence against the intended accused. So we have here three extremely serious findings that are underpinning the allegation of abuse. One is that this is an attempt to stop the continuous reportage by Ms. Mon. The second is that the vilification goes beyond Mr. Zuma and has been taken up furiously by his supporters. And thirdly, there has been evidence manufactured to falsely implicate Ms. Mon. Those findings of the High Court, strong as they are, simply demonstrate the utter lack of prospects of any success on appeal. This is why the court says if we assume that the only basis on which you will be appealing is this subsidiarity, then you have no case. But these other findings, and that is why in the replying affidavit it's expressly stated that it is apparent from the judgment that this appeal has no prospects of success. So, to round up then this first topic, if you are to decide this on the facts and not on the legal debate, interesting that as it may, you will find that Ms. Mon expressly dealt with prospects of success in the founding, expressly dealt with prospects of success in the reply, the judgment expressly dealt with prospects of success, and if yourselves have regard to the judgment itself and the findings that it makes on uncontested facts, because these facts that I've cited are uncontested facts, two of whom arise directly from the affidavit of Mr. Zuma as demonstrating the hostility and the animus, and then the manufacturing of the evidence. So it would be clear that this case has got zero prospects of success. So the charge is contrived, the allegations are manufactured. We then go to the second issue of exceptionality. We must make one point clear at the outset of our address. The first is that you are a court of appeal. You are not the court having to decide whether exceptional circumstances exist or not. That has to be decided below. You only have to decide whether the outcome of the court below is correct or not. And when you do that exercise, you are not going to look at the reasons given for the judgment, because there is no appeal against the reasons. You will look at the outcome of the judgment. So, on the three areas, and the judgment I've referred to clearly deals with all three areas. Exceptional circumstances, you will find this from page 581 at volume 4 of the record, where the judge addresses himself to exceptional circumstances. It's 581, not 581. 578, that's where it starts. From paragraph 7 to 581. Yes, that's where it starts. So the learned judges address themselves to exceptional circumstances, and they deal with all of the authorities, from Justice String to the most recent Knoop judgment, and all the way. And they then explain from paragraph 26 why the arguments of Mr. Zuma were flawed, and they explain the reasons why those arguments were flawed. And so those are the passages in which they deal with exceptional circumstances. The question is whether or not the conclusion that there were exceptional circumstances in this case can be impugned. Number one, it cannot be impugned that a prosecution of a journalist designed to prevent that journalist from reporting, and with the corresponding disadvantage it places on the public from receiving information, itself implicates Section 16 of the Constitution. Number two, it cannot be denied that a private prosecution in itself, and this is a point made by Mr. Badlander, is an exceptional circumstance. The default position is that the NPA does prosecutions on our behalf, and the exception is for private prosecutors.
Sorry, Mr. Director, may I take you back a little bit? You submitted that in considering exceptionality, we should not look at the reasons for the judgment, but rather at the outcome.
Yes.
When I read the New York judgment, I saw that there was a lot of criticism directed at the reasons of the court of law. In fact, at some stage, the court said that that court had shirked its responsibility. So my question is, what would then be the point of alluding to that if it is completely irrelevant? If
No.
we should not consider it at all, and consider only the outcome.
No, the law is simple on this topic, Justice Moleman. You cannot overturn a judgment because you disagree with the reasons. You can only overturn a judgment because the outcome is wrong. So you can write in the judgment that it's a salutary principle that judges must reason their judgments out. But you cannot say, I find that the judgment was wrong and therefore I'm overturning it because of the paucity of reasons. That is not the law. It is required that judges must provide reasons for their judgments. But the correctness of the judgment is what is before you. We're asking you to dismiss the appeal because whatever deficiencies can be identified in the reasons, that's not a basis to overturn a judgment.
So your response is that those were just comments that were made to emphasize the importance of giving reasons,
Precisely.
but not to say that the reasons themselves have to be considered in detail.
No, the reasons must always be considered. The question is, when will a court of appeal overturn a finding of a court below? A court of appeal will overturn a finding of a court below if it is satisfied that it was wrong, the conclusion was wrong. If, for instance, an application is brought and it is dismissed, you have to dismiss the appeal if you come to the same conclusion. But you cannot say, we think that he was right in dismissing the appeal, in dismissing the application, but because it did not give reasons for it, therefore we will grant the application. So the question is, when will you interfere? You will only interfere if you come to the view that the outcome was wrong. So you obviously must always encourage the judges to provide reasons, and the reasons must make sense, but you cannot use that as a basis to overturn a judgment. That's not the law. In fact, what I'm saying is an express finding of this court by Justice Rogers. In the...
I think the point you're making is the following, which is a fairly trite proposition.
Yes, indeed.
And that is an appeal lies against a substantive order of the court rather than the reason.
Yes, indeed. I don't...
I think all you're doing is you're sort of fleshing that basic proposition.
Yes, indeed. Yes, I don't need to look at authorities on this. It's truly trite. Now, so I've made the first two propositions about exceptionality. The third, which was actually pursued by my client, is the exceptionality of a former state president prosecuting a journalist. This is a truly exceptional circumstance. It does not happen often that a former state president prosecutes a journalist. The fourth is what Justice Ponan already referred to in the exchange with Mr. Badlander, which is the finding is that there has been an abuse of the power to privately prosecute that is conferred by a statute in terms of Section 7 of the Criminal Procedure Act. Now, let me spend a minute on this. Mr. Zuma is in fact engaged in a cynical manipulation of the legal system. That is truly what is going on here, because sometimes the term abuse masks what is truly happening. We are talking about a cynical manipulation of a legal system. Section 7 of the Criminal Procedure Act, on which he purports to rely, is not to be used to punish. It is not to be used to harass. It is not to be used as revenge. It is not to be used as an instrument to settle a score. It is to be used for legitimate reasons. All public power, because Section 7 is in fact statutory power, can only be used for legitimate goals that the statute contemplates should be used for. One cannot turn that on its head and seek to achieve ulterior goals. When one does so in circumstances such as this, where in the first place they turn the prosecutor, Mr. Downer, into an accused. In the second instance, they turn the journalist into an accused. They are manipulating the instruments of the law. And this has serious consequences for the constitutional order. It truly does. And when the judges do not stamp out this abuse clearly and within the first available opportunity, they inevitably encourage it because they show that the cynical manipulation of the system pays. And that is why you have to look at this case deeply and seriously, because it has implications that go beyond these two parties, because it has implications for the rule of law and for the authority of the judges under Section 165 of the Constitution. And that is why we say it is a truly exceptional case. And Mr. Butlander was not exaggerating when he said, if this is not an exceptional case, we will never get an exceptional case. It will in fact become a norm. And that is in fact one of the unique features of this case and how perverse it is that Mr. Zuma's constant cynical manipulation of the legal system has turned something that would have shocked you 2 years ago into a norm. So we would say that there can be no doubt that the outcome of the court below as to the existence of the exceptional circumstances cannot be faulted. And I have already referred to the specific findings that were made by the justices, particularly the finding of manufacturing facts.
I'm trying to wrap my head around what you're saying now.
Yes.
On sort of the uniqueness of this case.
Yes, there's a light that's blinding me. I'm terribly sorry. Yes.
And I'm not saying what you're saying is not valid. I'm trying to imagine a situation where an ordinary citizen, assuming we remove the former president's status from him, he's an ordinary citizen, comes to court in terms of Section 34 of the Constitution and says, I understand I have a right after this and this has happened, automatically I have this right to come before this court. How can it be an abuse, if anything?
No, I am not suggesting that.
To take everything off on his status and everything as an ordinary citizen now.
No, the judgments we rely on, there are three that we rely on that found. Okay, there's a problem with my machine. I just want our heads. We've relied on 5 judgments. 3 of those are ordinary citizens, and 2 are Mr. Zuma, in which it has been found that the private prosecution, starting all the way from Solomon in the 50s, that was an ordinary citizen. The mere fact that Mr. Zuma happens to be the president who is facing a criminal charge himself adds to the exceptionality, but it has very little role on the abuse. The abuse shows that this is an exceptional case. And if anyone, whether it is Mr. Solomon or I think the other, yes, found, thank you, Gcilichana or Nundala and Van de Venter, any of those, if they had abused the legal system by running a contrived prosecution, and the court had stopped the prosecution, and then they had tried to get it enforced because of an appeal, then we would say to the court that they should entertain it, because what the court cannot allow is a manipulation of the legal system. The issue is Mr. Zuma should also not be excused from the rule that applies to the others. That's the true submission. So it would be the same outcome, whether it was Cilichana or Van der Ventel or Nundalan. It is in fact cynical for Mr. Zuma to say my status doesn't matter, but at the same time my status matters. Anyone who manipulates the legal system to achieve ulterior ends should be stopped by the judges. Then I want to move then to my third topic, which is the second element. I think let me keep it here because my computer is dead. Which is the second element of Section 18, which is this issue of irreparable harm. We have referred to the judgment of S versus Western Areas, a judgment of Justice Howie when he was president of this court, which makes a simple proposition. The appearance of an accused wrongly in court, and in that case, it's the state that was charging them, which the state is entitled to under Section 179 of the Constitution. But the appearance, even for purposes of bail, is an infringement of the right to freedom of movement. So here is the point. Ms. Mon, at the time she brought this application, was required to appear in court, I think, on the 4th of August. She is now required to appear in court again on the 1st of November. That appearance is a violation of her rights to freedom of movement. This is the same finding that was made by the full court in Johannesburg when it excused President Ramaphosa from appearing on the basis that it's the mere act of forcing a person to appear before an unlawful and an abusive prosecution. That, in a sense, gives legitimacy to the abuse, because seeing Ms. Mon in the dock in circumstances that are abusive is legitimating the abuse. And that is why when she won her case, she was then entitled under Section 18 to be excused from the appearances. There is an argument made in the heads of argument of Mr. Zuma that the prosecution will continue no matter what. Ms. Mon may decide to come and not to come. That's a different debate. If they want to go to an empty court, they can do that. But the fact of the matter is that Ms. Mon should not be compelled to appear in court on the pain of a criminal sanction, because if she doesn't appear there, she's committing another crime. So she is always compelled to appear in court. That harm can never be restored. It's harm that she simply can never get back. But the other problem with it is the chilling effect. It is truly chilling that a journalist in the position of Ms. Mon, I would even submit a prosecutor in the position of Mr. Downer, it is truly chilling that they must perform their duties under the surveillance and the constant threat, quite menacing threat, of a private prosecution. Because when you actually break this thing down, Ms. Mon gets a piece of paper which she reports about, and on the correct sequence, that piece of paper is already part and parcel of an application by Mr. Zuma. She gets a piece of paper, she reports it. It's a classic job of a journalist. And there are many judgments that say a journalist can get documents. They don't have to question their sources, whether or not the sources have got those legally or illegally or anything of the sort. What she is being charged with, let's be honest, is for reporting. That's what is being charged with, is for reporting. You have other gymnastics about Section 41.6 of the NPA does not concern itself with a journalist, it concerns itself with the disclosure of information that is from a docket, etc. The true issue around Ms. Mon is reportage. It's the core function of a journalist. And that is why we say it is truly spine-chilling to think of the consequences of what is happening here. And that is why this must be stopped, and one should not be beating about the bush in a case of this magnitude. So,
it's slightly more narrow than that. It's actually the timing of the report.
yes,
Because, truth be told,
yes,
if he
yes,
had waited a little while,
yes,
these would have, and if the documents had indeed been filed in court, they would have been public documents,
Yes.
and then she would have been free to report.
yes, yes,
So the essence of the complaint,
yeah,
as I understand it, I accept everything that you've said,
yeah,
but all I'm suggesting is that the essence of the complaint is far narrower. It's
Yes.
actually
Yeah.
the timing of the
yes, exactly. But that precisely shows why this is an egregious abuse. It's narrower than I tried to portray it. In fact, I gave it legitimacy it doesn't deserve. So we say that this is not a harm that she can get back. It's chilling, not only to her, but to everyone else who is in her position. It is also chilling because it is a violation directly of her rights to freedom of movement. That is enough.
Is the argument not that she's in that space and she should take it as it comes?
No, there are no journalists that are.
If one takes into account that Mr. Zuma feels strongly that his own rights are being transgressed, therefore, even if she goes, it's what she does. It's her job. It's a journalist. From time to time, we get all these criticisms.
Journalists are happy to be criticized, but there are no journalists in this country. There is not, in fact, a single journalist in this country right now who is facing a private prosecution. It's only Ms. Mon. And one cannot, in fact, I would say, sanitize the egregious nature of this conduct by saying it's par for the course. It's not par for the course. It's a journalist who has been singled out for punishment, vindictive punishment, not legitimate punishment, vindictive punishment.
This can't be dressed up as even to criticism
No.
of the journalist.
There's no criticism at all. Yeah. So what is happening is that she's turned into a criminal accused. And then all of the supporters, and the record is actually replete with this, all of the supporters celebrate her appearances in court in very cynical and vindictive ways.
Well, that's very worrisome.
Yes, precisely. And the evidence is so clear on this. So it goes beyond Ms. Mon. It's precisely this chilling effect. And then someone to say, well, take it. That is what happens to journalists. That is not what happens to journalists. Then you have, so those two submissions are enough.
But it shouldn't be happening.
Yes.
I'll say if it does happen, it shouldn't be happening.
Yes, indeed, it should not be happening. And it's not the norm. I mean, this is the point Justice Muchumi is putting, that, well, journalists are criticized. Journalists are criticized. You write a newspaper report and you say, no, this journalist is stupid, whatever. But you don't charge criminally journalists. That's the chilling effect. Particularly the manipulation of the system of obtaining a summons under Section 7. It's the manipulation of the legal system. So then we then deal with the irreparable harm of Mr. Zuma. Let's really reflect on this. What is the harm to Mr. Zuma? What harm is he suffering? Because what he really wants to do is to continue the abuse, is to continue the manipulation of the legal system. But he now wants to do it with the imprimatur of the judges. Why should he do that? Why should the judges play along? If he wants to prosecute Ms. Mon, he will do that once his appeal, he is very confident about the prospects of that appeal. Once it succeeds, he will prosecute her. But he has lost resoundingly right now. He should be stopped from prosecuting. This thing has become a spectacle. Mr. Badlander called it a national joke. So, quite plainly, there is no harm, let alone irreparable, that Mr. Zuma suffers. So I began then, so I must now end with the abuse, but the court would have seen that the abuse is a theme of the judgment à court. We have dealt with this at the beginning of our heads of argument. What we ask this bench to take into account is that Mr. Zuma has an established propensity of vexatious litigation. We have cited here at least 12 separate instances where he has litigated with a lot of enthusiasm, but with no results. Now, one can try and neutralize the submission and say the mere fact that you lose doesn't mean that the litigation should not have been instituted. But the frequency and the nature of the cases that are being brought clearly illustrate that this is a vexatious litigant. You debated earlier with Mr. Badlander the question as to whether Mr. Zuma should be criticized for the 20 years or not criticized for the 20 years. That is not our bone to pick. What we want to illustrate in that fight, when the litigation was instituted by the DA to reinstate the charges, two things happened that contributed substantially to the delay. One was Mr. Zuma's, and we've cited this at page 7 of our heads of argument, item D. It was Mr. Zuma's decision to challenge the locus standi of the DA, which was eventually resolved in 2012 by this court. He is not an innocent party or a bystander watching. He is actively taking technical points to postpone the day of his reckoning. The second was the spy tapes litigation, of which even there he was a key proponent, which we've referred to as item E, which is the disclosure of the transcripts of the conversations recorded in the spy tapes. That is resolved in 2014, 2 years later. So it is not as if you are dealing with someone who is watching or witnessing a titanic battle between the Democratic Alliance and the NPA. You are dealing with someone who is part and parcel of the tactical litigation that is contributing to the prolongation. So far from being an innocent bystander, he is participating. He's taking every technical point that he can take himself. Now, that does not make those technical points illegitimate, but it explains the delay, that he is part and parcel of that delay. Now, all of those are finally resolved in item F in 2018. Item F at page 7 in 2018. And paragraph 3 of that judgment, it's a judgment of this court, paragraph 3 of that judgment records that within minutes of the address by Mr. Kemp, he had considered that his opposition to the DA's review had no merit. Within minutes. It's recorded in paragraph 3 of the judgment of this court, decided in 2018, that it took him minutes to say this defense has no merit. So it's easy now to say he shouldn't be blamed because this was a litigation brought by the DA. But when you examine the facts, it becomes clear that he is part of it and he cannot excuse himself from it. And then the final point on abuse, and it's a point that has already been made by Mr. Badlander. is that we are dealing with someone who is facing criminal charges. This is unlike a case where someone has been wronged. The NPA incorrectly decides not to prosecute, and then they decide, I'd rather than seek justice on my own. This is retaliatory in its nature. And once it's retaliatory in its nature, Section 7 prosecution is retaliatory by its nature, then it forms part of this picture of abuse. We would ask, therefore, that you should protect the administration of justice by dismissing this application. You should also impose a punitive cost order. This appeal is itself an abuse. The summons was an abuse. The opposition to the application was an abuse. The Section 18 was an abuse. The opposition to the Section. This appeal did not have to be taken because one could have waited until the appeal is decided on the merits. And at that point, everyone would be more sanguine and considering where they go. They did not have to run this round of litigation. They could have waited. But no, they've been hell-bent on teaching someone a lesson. But they have also made reckless accusations of bias. Mr. Butlander has dealt with those. The only thing to add there is, I think it was Justice Ponan who wrote the judgment in the funding litigation, where again the same person, Mr. Zuma, had made unfortunate accusations against the judges in Pretoria that they were biased. And that factor was taken into account in imposing a punitive cost order before this court. We would urge simply that the court should follow its own precedent on this issue by imposing another punitive cost order on Mr. Zuma. So we would submit, therefore, that the application is wholly without merit. The appeal is wholly without merit. It should be dismissed with a punitive cost order. Thank you, Justice Malema. Yes, indeed. Yes, well, if you are to apply a discretion, there is, I suppose, the first question that you have to follow is that discretion has already been exercised by the High Court, and this is a court of appeal. You are not exercising the discretion originally. The High Court has looked at the existence of those three factors. It has looked at prospects of success, and it has decided to exercise that discretion. The question on appeal is, if this is a discretionary decision, is there a basis on which a court of appeal can interfere with the exercise of a discretion, depending on whether it is a narrow or a wide discretion? And there are established authorities here. In fact, the funding case is a preeminent example on this point, that make it clear you can only interfere if discretion was not exercised lawfully with the appreciation of the correct dictates or with a misunderstanding of the facts. Then the question is, what case has been made before this court to interfere with the discretion of the court below? No case has been made. No case has been made that that discretion, after those three elements existed, has not been exercised properly in accordance with the behests of justice and the correct appreciation of the law. And so, therefore, as a court of appeal, your job is a relatively simpler one if this is a discretionary question. This fourth element is a discretionary question. The court of appeal simply asks itself, this discretion has been exercised. What is the basis on appeal on which we can interfere? The basis we know, those are the three requirements. It must be a misunderstanding of the law, a misappreciation of the facts, or some sort of a gross irregularity or gross injustice. Other than that, you leave the judge a quo as he decided. But the debate, as I've been listening, seems to be that this court is itself going to place itself in the shoes of the High Court. That, with respect, is the wrong approach on a discretionary question. But if you are to place yourself in the shoes of the High Court and exercise the discretion ex nunc, then the question that you have to answer is, what factors do we take into account? One of it could be the existence or otherwise of prospects of success. And on these facts that we have illustrated, firstly, you have the disadvantage, you don't have the record. But on the facts that you know and the quality of the reasoning of the judgment, you will come to the same conclusion that the High Court did, that these are very limited prospects of success. And for that reason, once those three statutorily ordained elements exist, you have to enforce the judgment. But the primary point I urge the court to remember is that it is dealing with a discretion that has already been exercised, and it is dealing with it on appeal. And the entry point is very narrow. Thank you, Justice Malema.
Yes, Justice. I might need slightly more because I'm dealing with both counsel. You know, they say we learn every day, and I want to maybe apologize to Justice Ponen because I said you can't say you've lost because you've lost, and I've been proven wrong. Because that's exactly what Mr. Ngaitobi has been doing. The entire argument, but all of it, is based on, I don't know how many, I was counting, I lost count, or how he has used the word abuse. Abuse. This is abuse, and abuse, and abuse. So he does exactly what I said you cannot do in cases of this kind, if you accept that they are meant to favor the loser. Of relying on the very judgment that is being appealed against as the basis for which you should give an 18-3. I mean, what on earth? Who would ever succeed in an 18-3 application if that absurd approach was to be taken? So if you take away the reliance on the very judgment that is being appealed against, Mr. Ngaitobi has said nothing at all, because he, without that, assume for a minute that I'm correct, that you cannot use the very abuse that has been alleged, which may be overturned on appeal one day, as your ground. If I assume for a second that I'm correct in that, then that's the end of everything that he has been saying, because there's nothing else except that Mr. Zuma does not like Ms. Mon, and she has insulted her, and what have you, and even these exaggerations about members of the family. I don't know who those members of the family are. Even the judgment says that members of the family, members in plural. If this was true, there would be no need to exaggerate. It's because it's false, so you have to exaggerate. The only evidence that is there is that there was a tweet which came from Mr. Zuma's daughter. That's it. But the judgment says members of Mr. Zuma's family, and it's among that counts Mr. Manyi. as such a member of Mr. Zuma's family. That's how fallacious this whole business is. Then there are no so-called members. At best, it's one member, and even that member, Mr. Zuma dealt with in his answering affidavit. He says, I can't be held responsible for the tweeting or social media activities of a grown-up woman who happens to be my daughter. Surely. But it has to be exaggerated so that it is made to look all this scary stuff. So, I'm sorry for the pun. If you disabuse our mind of this abuse point, which is used as the scarecrow, then the whole argument falls flat. The second issue is that Mr. Ngqokaitobi says that we are sitting as a court of appeal, which is correct. When it comes to exceptional circumstances, he understands very well that your job is not to look at the exceptional circumstances, but to examine whether the court à quo looked at exceptional circumstances. And he's right. But suddenly, when his prospects of success, he forgets that theory of his. Now suddenly, you must look at the prospects of success. But the same rule applies to all the requirements. This court is not, and I cannot emphasize this point more, this court is not being called upon to examine the prospects of success afresh, so to speak. It is only merely called upon to adjudicate whether the court à quo, as Mr. Ngqokaitobi correctly points out when it comes to exceptional circumstances, dealt with that issue properly or not, number one. Number two, to understand this entire issue, one has, and I'm saying this because I said it in the morning, if we don't appreciate that there is a difference which Mr. Ngqokaitobi appreciates when it suits him but doesn't appreciate when it doesn't. There's a difference between 18.3 and 18.3 application and an 18.4 appeal. That, Justice Mulimele, the Madam Justice President, presiding judge, is an explanation of what you were grappling with in respect of what was said in KNOOP. Once the difference between 18.3 and 18.4 is appreciated, that conundrum, what looks like a conundrum, disappears. Let me explain why. That's why there's this notion by Mr. Badlander that KNOOP somehow departed from Tlameza and AfriForum. There's no such thing. All those, actually, if anything, KNOOP affirmed those cases. The only issue that Justice Wallace said at the end of paragraph 50 is the following. And he talks about an appeal, not the application à quo. He says, the usual principle that an appeal court, yourselves here, decides the appeal on the record before the High Court cannot apply in those circumstances. That's self-evident. If you do not have the record as the appeal court, you cannot then, postulate on those issues. That was held in Tlameza, that was held in UFS, and that is correct on appeal. And then it says, if the language of section 18.4 is the appeal section, not the subsection, not the 18.3. If the language of section 4 confers a discretion, is that a full discretion or a power combined with a duty to exercise that power on proof of the requirements for its exercise? These issues may warrant reconsideration of the approach in Justice Alliance on an appropriate occasion. This is not even that occasion, because here we are not dealing with the issue of prospects of success on appeal per se. We're dealing with whether the court à quo in 18.3. So, to the extent Justice presiding was correct, that how can anybody suggest that KNOOP departed from Mtlameza and UFS, when Knoop says in so many words that there's a dictum that supports this approach, but in both cases, in Mtlameza, the record, the main appeal was not before this court and so on. And it cites Justice Alliance explicitly, and at paragraph 48, it deals with the UFS court. So this is just obfuscation, deliberate obfuscation of what must happen in the court of law and in the appeal. So this is simple. Now we're told, no, Mr. Ngwatobe actually says, you cannot prosecute a journalist. So you must make a decision on this appeal, on this sentimental stuff about, what is it, preservation of justice and what have you. No. This is a court of law. It's not a court of, exaggeration and hyperbole. If it doesn't matter whether you are a journalist or the Pope, if you have not pleaded the requirements of law that are needed to establish your case, you must lose. It doesn't matter how sympathetic you could be, an orphan, whatever. If you have not pleaded the requirements of the law, how can you succeed in a court of law? Just out of sympathy.
But didn't he clarify that by alluding to the fact that in this instance, the law says for private prosecution to take place, a certificate must have been issued, and in this instance, it not been issued?
No, well, that is absolutely wrong. That actually is taking the court for a fool. Of course, you must have a nolle prosequi certificate. What do we have here? You know, this kind of thing really. We have a situation, the facts are very clear, Madam President. In fact, if talking about the chilling effect, is the facts of this case. Contrary to what Mr. Badlander tells you about the so-called, when this fails, then Mr. Zuma brings another case, that's false. Because, in fact, that's what he says, or not him, Mr. Downer says under oath, which Mr. Badlander repeats in his heads, which is wrong. What actually happened is this, and I'm saying that because I was there. On the 21st and 22nd of September, there was a hearing of the Section 106(1)H. Ironically, these people who are telling us about Stalingrad will not tell you that that very hearing would not have happened if Mr. Zuma had not said, I'm waiving my right. He was in jail at that time. And in terms of the Criminal Procedure Act, he's entitled to be present in a criminal court. We all know that. Mr. Zuma, this very Mr. Zuma, who's so vile and delayed, says, it's fine. You can continue with your Section 106(1)H in my absence. I'm waiving my right to be present. This is the Stalingrad master. And then the case happens. In that hearing, I say to Justice Kuhn, we've been running with this case since the May of that year. But I say now, something else has just now happened. In August, which was the previous month, while Mr. Zuma was in jail, his military doctors sent a document which was marked confidential, it says. And that document was leaked deliberately by the prosecution to Ms. Mon. And therefore, I'm asking for leave for you to allow us to bring that as another ground. Justice Kuhn, and I say to Justice Kuhn from the bar, admittedly, I say, on this we have instructions from Mr. Zuma to institute criminal proceedings. And I know it has not yet happened, but I'm telling you. Then Justice Kuhn says, not all these things, that the reason why Mr. Badlander started at paragraph 246 is because he wanted the court not to be aware of what Mr. Kuhn, Justice Kuhn, actually said. It is not true, it's false, actually. to say Justice Kuhn rejected this issue about the disclosure of Mr. Zuma's information. Instead, Justice Kuhn actually said that you must go and lay a charge. Well, not in so many words. I'll read it out. Yes, this is what he says at 240 of his judgment. Not 246. Let's start where it actually starts. He says, as the complaint was only made, in the previous paragraphs, he cites section 41.6 and so on. And he says, as the complaint was only made in argument, which by me, and I confess I did that. And then in reply, Mr. Downer did not have an opportunity to respond thereto. I accordingly also did not have the benefit of the issue having been fully dealt with in argument, and we are told that he actually dismissed it. And then he says, in those circumstances, I consider that it will be improper to consider the request of any such referral further in this judgment. Apart from that procedural difficulty, I have doubt whether the wide terms of Section 41.6 are necessarily constitutional and or would necessarily find application on the facts of this matter. Prima facie, it would not, in my view, be unlawful for a prosecutor to deal with the inquiries from the press to ensure that the public is properly informed of the work of the NPA and the progress in investigations, which inevitably might result in the disclosure of information which came to his or her knowledge in the performance of his or her functions in terms of the NPA Act or any other law. I would have thought, is speculating, that Section 41.6 would not, for example, prohibit a member of the NPA in response to inquiries from a journalist, which this was not, because here the whole interaction was initiated by Mr. Breitenbach, there was no inquiry from a journalist, to confirm or deny that a particular suspect might or might not be formally indicted on particular charges, or the assistance regarding particular investigation in another jurisdiction was being pursued. And then this is what he says, the showstopper. But these are simply ruminations without the benefit of having had considered argument. 41.6 out clause such conduct, then a formal charge in that regard can be pursued, where the proper application of Section 41.6 can be fully ventilated and its proper interpretation determined. That's all Justice Kuhn did. He didn't do all these things that he's being falsely accused of. He says, if you are aggrieved, I'm making my own ruminations. Is it constitutional? Remember, though, how important that is. Because here, none of these parties, including Ms. Mon, challenges the constitutionality of Section 41.6. So this court has no option. It doesn't matter even for Justice Kuhn. We, as people talking in the street, might say, wouldn't this be a bit drastic if it was applied to a journalist? But until somebody takes it to court and challenges its constitutionality or say that there must be a journalist exemption or whatever, it must be applied as it is. What does it say, that section? It's very simple. It's being complicated by the other side. The section says you will be imprisoned for a period of up to 15 years. That's how seriously it is taken. If any person discloses information, forget this thing about confidentiality is a red herring. No, there's no need that it should be confidential. If you disclose any information to any other person, when that information was gained in your job as part of the prosecution without the permission of the NDPP, full stop. Why does the law put 15 years sentence to this, sometimes higher than even murder? Because the law wants to tell us that the integrity of the prosecution services must be such that a prosecutor should not just go around trying to get rounds in a tavern and say, oh, well, I'm prosecuting my Leonard, whatever. And in that case, there's there's a photograph of this and that and the other. If they do that, they must go to jail for 15 years. This is not a small matter. And therefore, when the members of the prosecution disclose to Ms. Mon such information in these circumstances, and it's not true that this is just about timing. No. And in fact, even if it was about timing, the timing is very simple. At 11:06, Mr. Breitenbach, or rather, Mr. Downer does his affidavit. At about 5, I might get the times wrong, towards 5 o'clock, Mr. Breitenbach, unprovoked, picks up the phone, calls Ms. Mon, or WhatsApp, I'm not sure, but initiates the contact. Where are you? Are you in Maritzburg? She says, no. She said, no, you don't have to come because there's going to be a postponement and there's an affidavit that's going to be sent and all that. And then he says, please send it to me. Here's the thing that really it means people are being taken for fools here. Mr. Breitenbach says, I will give you the information provided you do not publish it until the document is filed. Why would he do that if now we're told, no, the document was actually already filed? That's just absolute nonsense. Because the deal of saying you may not publish this until it's filed means they knew that what they were doing is wrong. So they say, please hold on to, I'm giving you the information, but hold on to it. The filing then happens the following day on the 10th. And indeed, as primed, Mr. Downer, who's a participant in this thing, Mr. Downer is told by Mr. Breitenbach, please tell me when you file so that I can tell Ms. Mon. He does exactly that. So it's like a bank robbery. The one points at the teller, the other one keeps the car, the other one is driving, the other one is checking whether the coast is clear. And then you tell us, no, the one who was checking whether the coast is clear is fine. Where's the actus reus? Says Mr. Butler.
Yeah, I was going to ask you.
The actus reus.
Where is the actus reus?
Yes, exactly.
Up to that point.
Thank you very much. The actus reus is here, as in the example I've just made of a collective bank robbery. Mr. Downer.
Now talk about Ms. Mon, up to that point.
Yes.
Where is the actus reus for the
Ms. Mon, that one is very simple. It is this. Firstly, for the purposes, just to cut time, Justice Ponan, you must postulate for now that Mr. Downer has done, and Mr. Breitenbach have done all the wrong stuff. So we're just checking whether Ms. Mon is also in the net, so to speak. Well, Ms. Mon's role in this is that she is the recipient of these proceeds of crime. There is a crime, for example, in our statute called receiving stolen property, knowing it to be stolen. I'm just using that as an example. So what you do in that crime, you punish the thief. That's the person who goes to break up at Woolworths or whatever. But you then punish the person who receives, the recipient and it might be that she might go to the criminal court and say, oh, well, I thought Mr. Breitenbach had the permission of the NDPP. It's fine. Then she'll say that. But she cannot be acquitted through the back door and made to look like an angel when she received these proceeds of Mr. Zuma's medical information, people. You know, which one of us here would like their medical information to be put around to a journalist?
In her case, the mere receipt of the information constituted the actus reus for the purposes of a criminal offence.
Yes,
I'm just trying to get clarity.
No.
But I'm just trying to have a sense as to exactly what it is we're talking about.
Okay, let me explain it like this, maybe. If someone steals my car, right, that person is guilty. That's the Downer-Breitenbach side of the thing. If someone else then is takes the stolen car, that person may not be guilty of the same crime or in the same manner as the one who actually broke and did the thing. But I'm saying this is trite actually. In the scope of the criminal law, even in corruption, I think is another good example. We all say glibly, there's a corrupter and a corruptee. Of course, you must punish the corrupter, but you also punish the corruptee, which doesn't happen often in this country, because it's usually a private company that goes and tells a government person, please do this, and then we all punish the corrupter, which is fine. But we must also punish the corruptee. It's the same axis. If a journalist or an engineer, it's irrelevant that she's a journalist, whether it's an engineer or an accountant or whatever, or the person sitting in the tavern, in my example, once that person is a recipient, if I say to them, look here, I'm giving you this photograph, you must give it to your friends, or don't do anything with it if you like.
Let's see if I can assist you.
Yes.
Why I'm asking you this.
Yes.
I initially understood that the complaint as against her was that she published
No, that's another red herring. That's actually the most irrelevant thing. There are two red herrings which you are fed with. One is the one of confidentiality. This case has got absolutely nothing to do with confidentiality. The second red herring is this thing about publication. It's got nothing to do with publication. The Section 41.6 is very clear. It says you may not give information. It says nothing about publication. I don't know where that came from.
That's why I asked the question. It talks about giving information. I was wondering how.
Yes, it's about giving and receiving. That's all I'm saying. I'm sorry, Justice Partner. Sorry, yes, thanks.
What is, and this is where you started to deal with this. My sister presiding asked you about the knowledge prosecution.
Yes.
What is your submission as
Okay.
that is concerned?
Good. Thank you. I'm sorry. It's just that I just had this misrepresentation of what Kun Jay said. It just gets me here. No, the answer to that is this. For lawyers to talk like this is actually embarrassing. Not especially here in the SCA, where we know about the endumeni, what we call the endumeni approach to interpretation. This is what happened, Justice Ponan. It's very simple. In January of 2022, the prosecution, the NPA, made a decision. That decision was, it's in writing. We decline to prosecute any person to do with this matter. Please mark those words. This is in January. In April, I'm sorry, no, it's not January, it's the 1st of April.
Let's just see if I can
If you can just indulge me, please.
If I can assist, because this is what I'd like you to deal with. There was a first knowledge prosecution certificate
Of the 6th of June, yeah.
Okay. So, in relation to the first certificate, what is the submission? Is the submission that covered Ms. Moore?
Yes,
Okay. In relation
to the second one.
Then, of course, if the first certificate covered Ms. Moore, it's not necessary to consider the second certificate.
No. That's not true. I'm sorry, that's not correct. Okay. And that's why I was taking you through this journey. If you indulge me, please. Yeah. I'm saying, Justice Ponan, they take a decision. This is very important. They take a decision on the 1st of April. We will not prosecute any person. That's what they say. But in June, on the 6th of June, and then they start saying, no, you're not entitled to do nolle prosecute. We write a letter, we threaten them, we say, we're going to give you, make an application to compel you. Then they give in. In June, they then give us the certificate. Deceptively narrowed certificate. They are sitting with a decision. We didn't know this by that stage. We only knew it this year when we got a record in the Ramaphosa matter. They deceptively narrowed that certificate to refer to Mr. Downer. Deceptively. I say that advisedly. Then, of course, Ms. Mon says, aha, I'm not mentioned in the certificate. She writes to us and says, you must withdraw the charges against me, what have you. I'm not in the certificate. This is in September now, after the 5th or 6th. Then we write to the NPA. We say, NPA, imagine this, we didn't even know the truth of that, but we suspected that there's some shenanigans. We say, NPA, you remember when we did the complaint to the police, we said this complaint covers a whole lot of people who may be directly or indirectly involved, the usual legal stuff. So please tell us, Ms. Mon has now taken this point. We want you to tell us is she included or not included in the June certificate. Failing which, we will go to court. They give in. They first say, no, she's not included. We say, okay, fine, then we will compel you. Then I think they had some meeting. Then they say, okay, we'll give it to you. On the 21st of November, they then gave us the new certificate, the second one. It now says what the first one should have said. It says, I Elaine Zungu, NTPP, what, I decline to prosecute any person in connection with this matter. Mr. Nguraitobi then comes here and says, Ms. Mon is not mentioned. Of course she's not mentioned, but lawyers are supposed to interpret document. What does it mean? What did they mean when they said, I decline to prosecute any person? The exercise is very simple. Is Ms. Mon or myself or anyone else, because if it said any person, it could mean all the 60 million inhabitants of South Africa. Obviously, it didn't mean that. It says any person in connection with this matter, and that narrowed it down to 5 or 6 people or whatever. And it is at that point, Justice Ponen, that we then say the interpretation, in fact, it's not even an interpretation. Let me, please allow me to do this. Let me take you to the application for leave to appeal. Just to show you the kind of thing we're dealing with here. It's actually, I have no words for it. But these same people, I'll just paraphrase, you'll find the application for leave to appeal at 459. And the attachments there to start at, 472. This is the kind of people who are dealing with here. In the Ramaphosa matter, which happens in January, about the same no less prosecution certificate, by the way. Because that one was a review, we then say we want a record. We get the record. The record makes it clear that in April already, before the first certificate, the decision that was taken was about any person in connection with the matter, which included Ms. Mon already, before the deceptive certificate. But you don't have to believe me. You must believe what the author of the certificate says. You'll find that at 477. Paragraph 6.4. She says in an affidavit on the oath in the Ramaphosa matter, at the relevant times, the first respondent, whether in person or through his attorneys, first respondent there is Mr. Ramaphosa, of record from time to time, it's Mr. Zuma, the first respondent. Mr. Ramaphosa was the applicant. So it says, at all relevant times, Mr. Zuma, whether in person or through his attorneys of record from time to time, only identified 2 suspects, Advocate Billy Downer and Karen Mon. No mention is made of the applicant as a suspect. That's what the NPA tells us, right? And then, but we're told, no, we must forget all that. And then the next, look at 487, paragraph 23.3. This is now from the heads of argument of the SC who represented them. At 487, madam, 487. Paragraph 23.4. Their counsel now relying on the same thing says, In SAPS Peter Marisbeck, CAS 309-10-21, that's Mr. Zuma's complaint to the police, only 3 possible suspects are identified: Advocate Billy Downer, Karen Mon, and possibly Advocate Breitenbach. But this court must now fall for these cheap tricks. The same people who are telling you that no, all these things that you have been told here this afternoon, she's not named, are saying that the court must close its eyes to the fact that the author of the document says that she was part of it, and the nolle prosecution. In which world can that ever be done? And by the way, let me say this in fairness to my learned friends, because they don't have another chance to come back. That part that I've read, just to be frank with the court, belongs to a part of the application for leave to appeal, where we say this evidence that I've just referred to is going to be, it will form part of even the petition to show that the acquittal, as I call it, of Ms. Mon by the civil court was wrong. Now, we said that because at that stage we had not done the applications for leave to appeal. I can tell you now, I'm not testifying from the bar, that since then the application for leave has been, as Justice Ponan pointed out, has been dismissed. And what is, or at least our instructions now, is that when we do, because we don't want to waste the time of this court, and I know it's been done before, those 2 appeals will, at least there'll be an application to consolidate them. Let me not say they'll be consolidated, because that's not in my power. But there'll be an application to consolidate those applications. So there will be no need anymore to make an application to introduce this evidence as so-called new evidence, because it will be part of the whole thing. So think of it like this. One day, this court will be sitting with a version that says Ms. Mon was not mentioned from the state, and then another version from the state that says Ms. Mon is mentioned. Obviously, she's one of the people who are mentioned. That's the kind of mambo jumbo that the courts are expected to believe. Now, you might ask yourself this. Take yourself a bit from this. Take a deep breath and say, if they are so innocent, why are they here? Why didn't they laugh this thing off and say, okay, this prosecution, where's the actus reus? The prosecution would be done by now. But no, they are more wasting money. They accuse us of Stalingrad. They are wasting money to avoid their day in court because they know that there are no answers to these charges. And that is why they're here. Because they should be saying one of 2 things. Either we'll call your bluff and we'll remove Mr. Downer from the prosecution, and then, where will you get your Stalingrad now? And then you have the prosecution. Or they should say, okay, bring it on. This thing is so frivolous that we will be acquitted even by a magistrate. No, they're avoiding, they're doing what Wallace J.A. said should not be done in the Moyo case, of allowing well-resourced accused persons to use the mechanisms in the civil courts to achieve what should be dealt with in the criminal courts. That's what's wrong with this picture. And then they tell you that there are no prospects of success. This court is going to turn against its own judgment in Moyo, where it said you must not go to the civil court. If you have a problem, do what Mr. Zuma did before Judge Kuhn. Raise the issue. Do what Mr. Zuma is doing now before Judge Trili. Raise that issue in the criminal court. Mr. Zuma has not, the Stalingrad king is taking his objection about Mr. Downer to the criminal court to avoid delays. The anti-Stalingrad crowd is leaving the criminal court, go to the civil court, go via Paris and whatever, instead of taking the N1. That's what is this? We cannot even, the people who are guilty of Stalingrad here, if there's anyone, it is them. Because they should have their so-called day in court and let it go. Secondly, and And this shows the futility point. I like Mr. Butlander used that term. It shows the futility of this thing. What does it matter? And we said this to the court again. If you grant or not grant that relief, because of two reasons. I've already mentioned in the morning the first reason, that the delays are caused by the recusal application, not by this. This is actually, this has nothing to do with either a delay or non-delay. The criminal court, the criminal case of Mr. Zuma will only take place once the removal application has been finalized, or once sanity prevails and Mr. Downer recuses himself, whichever happens first. But here's the thing. Let's assume that this execution order is granted. How does that remove the perception of bias on the part of Mr. Zuma? How? Because Mr. Downer will still be susceptible to the appeal process, which may find that he must be privately prosecuted. So on that score alone, he's disqualified from prosecuting Mr. Zuma. So what we do here or don't do is completely irrelevant to that question. Because even if forget about all this, let's assume Mr. Zuma goes to the removal court and says, I am telling you now, court, that Mr. Downer his matter is in the SCA. That SCA or the Constitutional Court may one day make him an accused in the private prosecution. And therefore, I don't want to be prosecuted by him because he bears a grudge against me merely on the possibility that he will be prosecuted. So this is an absolute waste of the court's time. I'm sorry. To wrap up, yes. Okay, thank you. Let me just then go to... And then we're told that Mr. Zuma must be punished for exercising his right of automatic appeal, which the Act gives. And I agree with Mr. Butlander with respect on the issue of the two, on the point postulated by Justice Ponan, that the intention of the legislature was obviously to do away with the application for leave to appeal and deal with the issue of appealability. But here is what our Mr. Nkaitobi tells us. No, you are not supposed to worry about the reasons. But how can that be? And Justice Ponan says, well, that's the trite proposition that what you appeal against is the order. No. This is a different kettle of fish. That is true in a normal appeal. But how can it be true in an appeal where the legislature, Parliament in Cape Town, says, if a court orders otherwise as contemplated in subsection 1, the court must immediately record its reasons for doing so, and the aggrieved party has an automatic right of appeal. That means, why? What's the purpose of section 18.4.1? If that is true, what Mr. Nkaitobi is saying, then it would be purposeless. The reason why the legislature legislates that you can never give, in an 18.3, you can't do what courts sometimes do, which is just to give you an order and then you can deal with it. You can even appeal on it. It says, no, you can't do it. By legislative decree, you must give reasons. Why? It is because every court, and Justice Mulimela was quite correct, every court that has dealt with these matters, Tlameza, UFS, KNOB, has gone on to scrutinize, as it should, the reasons. In Tlameza, the issue was whether the remarks of Matojane J, as it then was, in an earlier case, should be taken into account. And the court grappled with this and came to the conclusion that Matojane J's remarks should be taken into account and therefore gave his judgment. In Free State versus AfriForum, the AfriForum was saying Afrikaans students are being prejudiced because now there's an English medium of instruction and all that, and the world is going to fall down, as Justice Mutle was saying. It was a question of statistics. So is it 20 years or is it not 20 years? I mean, it's that simple. So they came to court and came with hyperbolic statement. They said hundreds and thousands of students will be prejudiced. The court said, no, let's look at the facts. And it showed that there were only 386 students and 0 of the entrance. And then the court said, because of these reasons, we are rejecting it. In Knoop, the same thing happened. In Knoop, it was the Gupta, Mrs. Gupta, and the business rescue practitioners. And that is, and the Kotako granted, as I said earlier, even orders dealing with now how the BRPs are supposed to. And Justice Wallace went into the reasons and said, no, you can't include this. This is wrong. And said something important here. Even if the order was to prevent dishonest, I can't remember the actual, it's in our heads. And it goes to this abuse story. In Knoop, the court said, even if you are dealing with dishonest or abusive people, you still cannot grant exceptionality on that basis. The exceptionality has to be scrutinized carefully by this court, and that is why the abuse theory is completely wrong. Because what it says is that forget about the 20 years that is distorted. Forget about that the Stalingrad thing is just made up. Forget about the fact that there might be another prosecutor. You must just say it's an abuse. But the abuse comes from those facts. It comes from the 20-year theory. It comes from the Stalingrad theory. It comes from the indispensability of Mr. Downer. So if you take away the substructure of the abuse finding, how can it survive? And if the abuse finding does not survive, nothing they've said will survive. Because both my learned friends have pegged their entire case on this finding, on this abuse finding. Apart from the fact that, 2 minutes please, Justice Parliament. Apart from the fact that when it comes to the I want to end by going back to the prospects of success issue. You see, the task of this court is actually much simpler than meets the eye. This court must decide now whether the approach taken in Bila, which introduces what it calls the fourth requirement and defines where the onus lies, is correct or not. If it is, then what Mr. Badlander, I'm sorry, I have to do this. Mr. Badlander tells you, I can't go now, I'll just tell you. At paragraph 53 of his founding affidavit, he says, oh no, but we mention application for leave to appeal there. Well, they are both wrong. Firstly, I've said, in that paragraph 53, it says, on the, I'm sorry, I have to. It says, I submit, this is page 23, I submit that given these findings, after traversing the findings of the full court and the findings I summarize in paragraph 16, nothing to do with the application for leave to appeal. Remember, they don't even have it at that stage. Mr. Zuma's application for leave to appeal has no prospects of success. That's not the test. The test is not about application for leave to appeal. The test is prospect of success in the appeal itself. Right? That's what it is. I see there's some giggling behind me. But that giggling is misplaced because the test is very clear. It says prospects of success on appeal. And that's a completely different thing to prospects of success on the application for leave to appeal. Why? Because it goes back to what Justice Ponen was grappling with correctly. about whether is the fact that the application for leave to appeal has now been dismissed relevant or not, and I've submitted why I say it is not. So there's a big distinction. But forget about that. Let's be kind. Let's say prospects in application for leave to appeal also might mean application in the appeal itself, which it doesn't. But then what? Where do you actually now establish the owners? Let's say you've pleaded it now, to be kind. And then what? How can you say I've discharged the owners to establish prospects of success as a sangoma without seeing the application for leave to appeal, without considering the 12 grounds that are raised there? I don't have time now. And this court, the court accord, says if the prospects of success are only based on subsidiarity, then they are slim. How can that court even make that statement when at that stage it is armed with the actual application for leave to appeal, which raises plus con Evans, which raises the fact that, which raises Moyo, which raises stare decisis, which raises how can that court say if it's only confined to subsidiarity when it knows that it's not confined to subsidiarity? That is wrong. So the Moyo, what they do, all of them, is to actively stay away from the case of Mukhesi. You'll see in our list of cases, the case of Mukhesi. That's the case in which Mr. Ace Magashule and his co-accused is the only case that's post-Moyo, by the way. All these other cases they're talking about 1950s and what. But post-Moyo, Mr. Ace Magashule and his co-accused went to court and said, these charges, all these things, they are politically motivated, it's an abuse, what have you. The court said in Mukhesi, we can't help you, sorry, because the SCA said in Moyo that why must issues that are germane to criminal proceedings be resolved in civil proceedings? And because to do that is Stalingrad, and it's a form of delay, said Wallace J.A. And that application was dismissed. But they want to have a different outcome here. Why? Because there's one law for Mr. Zuma, and there should be another law for other people. The standard that was set in the Mukhesi case is what should have been applied in the Kotako. I know those issues will be dealt with in the appeal itself, but I'm simply saying, even at face value, the prospects of success in this matter are overwhelmingly in favor of Mr. Zuma, because if the case does not pass the first base of jurisdiction, or the Moyo, let's call it, forget about these labels of subsidiarity and whatnot. Let's say the Moyo tint test. Moyo and tint, the following rule was established. Courts should not countenance civil applications that are brought in the civil court regarding criminal matters, unless if it is in the interest of justice to do so. I can assure you, as I'm standing here as an officer of this court, there is nowhere where these applicants or respondents say that we must not be judged like in the Mukhesi case because these are the interests of justice and what have you. So the general rule applies, as we know in law, which is that thing should not even have passed the first stage. I'm not... Stare decisis, I don't even want to go there. All the cases, Solomon, Belichana, that they rely on, they say the exact opposite of what they say. Solomon says that if the only thing you are bringing to court is the ulterior purpose to harass the other person, then obviously it's an abuse of court. But this court knows that, this court said in Zuma versus DPP in 2009, I think it was Haram's JA, and it has now been reaffirmed in Redel recently, that it does not matter that you may have a so-called ulterior motive if you also have the intention to get a conviction. Mr. Zuma goes for pages and pages and pages in his answering affidavit saying, I am not doing this to punish anyone. I just want justice because my confidential information was taken away. Now, this court said, if you have, unlike what Mr. Ngugai Toby said, you do not only prosecute people that you love, or you prosecute all those people for which you don't have a feeling of retaliation. If somebody rapes my child, I'm going to have animosity against them. The fact that I have such animosity against them does not mean I must not go and lay charges. I must be disqualified because I also hate them. Yes, I do. Because they've broken into my house, stolen my car, or whatever. But how can that be a disqualifying factor? That's what Aram's JA was saying. Your ulterior motive, for as long as it is what Mr. Bradlander called mixed motives. So as long as you can, and there is no basis upon which this court or the court of call can say Mr. Zuma's version on the Plascon-Evans rule, where he says, I want justice, I want a conviction. On what basis can it be said that's far-fetched and it must be rejected? Yes, no, yes, I accept. No, you did. You gave me an indulgence. Let me round off then, Justice. I just want to say that if you look at this, I go back to where we started in the morning. My humble submission is that this matter resolves itself completely on the issue of prospects of success on the Bila rule. But even if I'm wrong on that, I say that the exceptionality is contrived. And also, Mr. Ngugai asked us, where's the harm to Mr. Zuma? How can you say that? How can it be harmful to Mr. Downer that there's a delay in the criminal prosecution? But it's not harmful to Mr. Zuma that there's a delay in his private prosecution. Which law works like that? The same delay in the prosecution is harmful to Mr. Downer, but when it comes to Mr. Zuma, it's not harmful. Please. As a court, please. Thank you, ma'am. As a court, please. We're indebted to the court. Thank you.